What is important for your clients to know and be aware of as their case is going through the trial process?
Yeah, I think the clients want to know that they need to take a part in the preparation process. So as but one example, I have a recent case where, the client is really just taking a hands-off approach. And, as alluded to in the prior question, I give my clients, if it's a contested custody issue, I give them the questionnaire form. I give them the factor charts that's going to help me start preparing for trial. It ultimately takes them to fill that out. So if they don't do it, we will need to keep hounding them and following up with them and stressing why they need to turn this stuff over, because it helps me to prepare for trial. And ultimately, again, you don't want to get to the point of a trial and now you're scrambling around trying to get the proper evidence, or you didn't properly give the other side the evidence with enough time for them to realistically review it and raise any objections to it. I have another case where my client is asking for maintenance, otherwise known as alimony, as well as child support. She has it in her head that, well, the other side hasn't turned over any of their disclosure, so why should I? And I've explained to her that the court is not going to be sympathetic to a tit-for-tat game. So if you get to the point of trial and you complain, well, gee, judge, I didn't get the proper disclosure, the judge isn't going to care at that point. All those issues have to be done pre-trial. And I've tried to explain to my client, and this is as best as an attorney can do, is explain the rationales for why you're doing these things. The step to compel disclosure, if the other side is refusing to give it, is to file a motion and ask the judge to issue a court order compelling them to respond to your disclosure requests. But the judge is going to be very unsympathetic to your motion if the other side comes in and says, well, gee, judge, the movement has not turned over their disclosure either. Certainly, if I were the judge on that case, I would say both motions are denied, and neither side gets disclosure, and we'll set trial dates without any of that disclosure being done. Oh well. Or a nice judge might say, well, I'll give both sides 20 days, and that's it. And I'm otherwise not granting any sanctions or counsel fees or anything else. So I think the clients and the parties need to be aware that they need to cooperate with their attorney. When their attorney says, I need X, Y, and Z, you can certainly ask for the rationale. It may or may not make intuitive sense to a particular person. But after the attorney explains it, why they need those particular items, you need to provide it. Otherwise, you risk not getting what you think you should get at trial.